Can everyone here agree that 12 heads are better than one? Shake your head.
Yes.
Yes, okay. Now it's important right now for you to understand that. We're not trying to trick you. There are no right or wrong answers. We want to know what you believe. Now during this process, would it be wrong of me if I were to ask you for your each individual own worldview? You know, we all have our own biases, resentments, beliefs. And I need to know, and I'm going to ask you to share with me, whether or not you're going to carry that with you into the jury box. Now, there's a concept that has gained momentum recently, and that is the concept of implicit bias. Does anyone here know what that is? No? Okay, well, I'm going to try to explain it briefly. Now, we all want to see ourselves as fair. Can we agree to that? Yes?
Yes.
Okay. We all want to believe that we're rational. Can we agree to that? Now, unfortunately, studies have shown that despite our best intentions, none of us are free from these biases. Implicit bias refers to unconsciously held beliefs that don't necessarily reflect our conscious belief. So, for example, you walked into the courtroom either Tuesday or Wednesday, and you saw a gentleman in a black robe. When we see someone like that, we can assume that they're a judge. And you made that decision pretty quickly. Is that correct?
Yes.
Okay. So what if you were to walk into a supermarket and there's a big burly guy with a long beard, clad in leather, and he's walking to a motorcycle. Let's see. Number 5. When you see that, do you see someone who's adventurous?
Yeah, I mean, I guess they're riding a motorcycle.
How about dangerous?
Not necessarily.
Okay. Now, you're making a quick judgment when you see someone like that, right?
Yeah, that's an implicit bias, right? Like,
I'm sorry?
that's kind of almost an implicit bias, right?
Yes, yes. Now, in that same token, you all walked in, whether it was yesterday, Tuesday, or today, and you look over at the defense table and you see my client, Mrs. Adelson, do you wonder to yourself, I wonder what she did? Number 2, you think to yourself, I wonder what she did, or I wonder what she is accused of doing?
I don't look that far into it. I mean, I don't know her from the next person, so I would just shoot her off on that person.
Okay. What about number 9?
No, sir, I didn't have that question.
Well, which one did you ask yourself? I wonder what she did, or I wonder what she's accused of doing?
Neither.
Did anyone ask that question of themselves, or say that to themselves? Number 23.
Yeah, I was wondering, what she is accused of.
Okay. I saw a paddle over here. Number 25. What did you think?
Yeah, like initially, I mean, it's just human nature to be curious. It's like, I wonder what this person was accused of doing.
Now, do any of you have anxiety or are claustrophobic that if you're in lengthy deliberations that you might want to just leave the jury room? Anyone at all? Now, going back to implicit bias briefly, does everyone here agree, and let's start on the first row, that you will make an effort to be conscious of implicit bias when you're considering the evidence in this case? Second row. Third row. Thank you. Now, when we were back in the jury room the last couple of days, some of you answered some of the questions. I think I might be able to, or I believe so. And you recall that we asked you to clarify that. First row? Okay. Why do you think we asked you that? Anyone?
Gauging our levels.
Because sometimes, I'd say just about every day in our lives, we face bias because we have a perspective of what the world should be, and we can only deal with bias if we can consciously are aware of how we feel and what's going on around us.
Thank you. Does everyone agree with that response? I need verbal.
Yes.
Thank you. So if a witness were to say, I think I saw this, is that the same as them saying, I saw this?
No.
Another important point, and I'm going to go to number 6. If you are selected as a juror and you hear the evidence and testimony, you go back into the jury room, are you able to say to another juror, well, that witness didn't say that they saw it. They said that they thought that they saw it.
Yeah.
Or they didn't tell you what somebody said, but what they think they overheard.
Yeah.
You can point that out. Number 12. Could you do that as well?
That's my duty. That's why I'm here.
I'm sorry?
That's my duty. That's why I'm here.
Number 11.
Good.
Number 16. Yes?
Yes.
Number 17.
Yes.
Ms. Kappelman covered the leader, so some of what I was going to cover has already been addressed, so I'm not going to repeat it, and certainly not here to waste your time. Number 23, would you say that you're naturally skeptical?
Yes.
Okay, when I ask that, what do you think that I mean?
Like, today's going to be a great day, and sometimes you're like, yeah, this something can go wrong. You better not, put all your eggs in one basket, so to say, and think everything's going to be great. You have to be open and know things can go wrong.
Do you question when somebody says something to you? Would you question whether or not they're being honest?
Yes.
So how do you determine whether or not they're being honest with you?
The normal things, look a person in the eye, if they're fidgeting in their seat or, not able to stay still or, they have conflicting statements or whatever.
Let's see. Number 19. Would you agree with that? Are you
Which
skeptical? Are you naturally skeptical?
Depends on the situation.
Give us an example.
Oh, well, like he said, if it's going to be a great day, I have to keep an open mind because I have no idea if it's going to be a great day or not.
You trailed off at the end.
I have no idea if it's going to be a great day or not.
Are you hopeful?
Not really.
Today might be a bad example. Now, you previously served on a jury. You said it was in California?
Correct.
Things are a little bit different out there?
A little bit, yeah.
In trials, I mean.
Well, the way you guys did this time is different. I'm assuming it's because it's sensitive information, so.
You said that you didn't want to have to do it again. Is that
Right.
accurate?
Yeah.
But it wasn't a bad experience?
No, I was not. I don't know. It was different than I was thinking, but it wasn't like horrible.
Let's see. Number 13. How do you avoid misunderstandings with people?
Through conversation.
Can you give us some techniques?
Primarily through asking questions to not only hear what they're saying, but then to get at what they're intending to communicate as well, both verbally and then non-verbally.
So it's important to listen.
Yes.
Number 14. Do you agree? Any other examples of how to avoid misunderstandings? Anyone at all? I'm going to call it yes, number 16.
Being aware of what you've actually been told versus what assumptions you're making.
I couldn't hear you.
Being
Sorry.
aware of what information you've actually received versus what assumptions you've made.
Okay, so avoiding assumptions. Okay. Number 12, I saw your...
Oh, I was just going to say that it's good to confirm your understanding of what someone has said, if that's possible.
So in other words, repeating back what somebody has said to you to confirm that you understood it the way they intended.
Exactly.
Okay. Number 23. I'm sorry, number 11.
Yes, sir.
When you were falsely arrested, how did you feel about the criminal justice system?
I was a bit irritated with it at the time.
Okay. How long did it take to correct?
About 3 weeks in total. I was bailed out immediately, so I only spent about 8 hours in a holding cell, but about 3 weeks of back and forth before I was fully cleared.
It's actually pretty quickly.
I thought so, but I was rather persistent.
Number 23, you agreed that that was a pretty quick turnaround?
Oh, yes, yes.
Okay. By a show of hands, does anyone think that the state could make a mistake? Yes? What about law enforcement? What about the state's theory of a case? Does anyone think that the state can be wrong in their theory of what happened?
Yes.
Did anyone not raise their hand? 23?
Oh, no, I
Oh,
raised my
okay.
hand.
Just making sure. Now, does anyone know people who keep large amounts of cash on hand? That's number 26. Do they have a distrust of the banking system?
Yes.
Okay. Now, I know at least my generation, my grandparents and my great-grandparents certainly had a distrust of the banking system. The Great Depression, people lost everything, right? I think we're starting to get into a point where I might not be able to relate with some people. So, number 6, do you think that it would be inappropriate or illegal for someone to keep large amounts of cash? Number 24. Have you ever made or received a personal call while you were around other people?
Sure.
What did you do so that those individuals didn't hear your conversation?
Usually asked to be excused.
You walk away?
Mm-hmm.
That's a yes?
Yes.
What if you couldn't walk away? How do you convey what you're trying to convey?
Then I usually ask if I can call back to the person.
So you would either try to walk away or you would continue the conversation another time.
Right.
What if neither one of those were options? Would you
well,
be vague?
Yeah, because if I'm trying to get, especially if I'm working, a lot of times I couldn't take a phone call, so I wouldn't answer it. So.
What if the person that you're with is the one who gets the call or makes the call? How do you know what's discussed?
You can, a lot of times hear what they're talking about.
Well, what if you can't hear? They walk out and you can't hear. Do you know what's discussed?
No.
Now, if the person comes back and tells you what was discussed, Do you know whether or not that was true?
No.
By a show of hands, has anyone ever said something that they regretted? Thank you. I know that nobody, and correct me if I'm wrong, but nobody here has ever worked in law enforcement, correct? Okay. Has anyone received any courses or done any type of law enforcement training? Even those that were in the military. Number 13.
Yes, somewhat.
Can you tell us?
It would have to be a sidebar.
Okay.
Due to the nature.
Understood. Anyone else? What about private security, private investigation? Anyone? Does anyone here like to travel? Got a few that don't. You don't like to travel? Number 9?
No, sir.
Okay. For those of us who like to travel, let me pick on somebody. Who raised their hand? Number 25. Is it generally less expensive to stay in an Airbnb or a hotel for a lengthy trip?
For a lengthy trip? I guess it depends on the area, but I guess recently Airbnbs kind of seem to be cheaper.
Now, there were a few people, and I didn't see the hands that have been involved in a divorce. Actually, number 11? You've been divorced?
Divorced?
Yes.
Yes, sir.
Okay. Did you have young children at the time?
I did.
But was it amicable?
It was.
Anyone not have an amicable divorce who's been divorced? Okay. Did you say things about your ex or soon-to-be ex that you didn't really believe?
No.
I'm sorry?
No, it was pretty cordial.
Oh, it's pretty cordial? Okay.
For me on my side.
Oh, on your side?
I was pretty nice. I think.
What about the other side?
Yeah,
Not quite as much?
I wouldn't know.
Do you know how she spoke about you during the divorce?
Yeah.
Was it nice?
No.
And that same note, by a show of hands, has anyone ever spoken poorly or said mean things about somebody else? Pretty much everyone. Does that mean that you hated the person? Anyone? The fact that there are no paddles up tells me that doesn't mean they hated them. Okay.
I think it means we're just mad at the time.
Thank you. By a show of hands or paddles, has anyone jumped to a conclusion before? You hesitated.
Well, I don't like to admit, but I suppose I have.
We're human. We tend to do that. It's not just analytics. We also have emotions that come into play. And that's how we interpret things, right? Now, for all of us who have jumped to conclusions, was our initial conclusion always correct? No. By a show of hands, has anyone had a knee-jerk reaction? Said something in that moment? Pretty much everybody? Okay. Number 7. Did you later realize that you misinterpreted what was said?
There have been times.
You're human. By a show of hands, has anyone ever planned a party? Now, I'm a visual person, so I wanted to list out some things that I wanted to talk to you about. So we're going to start with some definitions and concepts that I want to see how you interpret it. We're going to talk about the presumption of innocence, the burden of proof, jailhouse snitches, and we're also going to talk about some of the legal concepts that you're going to be asked to determine. Now, I think we've made it pretty clear. The law is going to be coming from the bench. I want to make sure that you can follow the law and that you understand what you're supposed to be doing. So, I'm going to call on somebody new. Number 18. Can you tell us what a presumption is?
When you are making an assumption.
Is it an assumption? Now, it's just like the presumption of proof of innocence. You're not making an assumption there, are you? It's something that you believe up until a point, right?
Yeah.
Okay. Does everyone agree with that? So, for example, you're supposed to presume that Mrs. Adelson is innocent up to the point if the state can prove their case beyond the exclusion of a reasonable doubt. What does that mean? What is beyond a reasonable doubt? We're going to get to that. Now, Ms. Kappelman already talked a little bit about what direct evidence is and what circumstantial evidence is, right? Does anyone feel like we need to go over that again? Number 17?
No.
Okay. Now, something else that came up. The state indicated a moment ago that evidence comes from the state, an indicator of their table. Evidence actually comes from the witness stand and in the form of exhibits, things that are presented to you. It's important for you to understand what I say, what Ms. Fulford says, what either the prosecutors say isn't evidence. It's argument. Number 20. You understand that?
Yes.
Number 14? Yes. You understand that?
Yes, sir.
Okay. So, if you interpret evidence different than we argue, what are you supposed to do?
Discuss it.
I'm sorry?
Discuss it.
And you're going to discuss it back in the jury room. Good. Does everyone agree with him?
Yes.
Getting.
Yes, sir.
I have one confused look. Number 19. So if you interpret something different than what the state or defense argue it to be, what are you supposed to do?
Discuss it, like you said, in the jury room.
How do you determine whether or not the state's right or the defense is right?
I don't know.
You don't know?
No.
Can anyone offer any suggestions? Yes.
Asked to review the testimony.
What else?
Reviewing the evidence.
I'm sorry.
Evidence.
Okay, so look at the evidence again.
To that point also, the court will give you specific instructions on how to weigh the evidence when we reach that point. You may continue.
Thank you. Now, presumption of innocence, we touched on it briefly. It's important. You must presume or believe the defendant is innocent. As we sit here today, you've heard no evidence. Mrs. Adelson is innocent. The presumption stays with her as to each material allegation in the indictment unless it's overcome by evidence, so by things that you're going to get up there, beyond the exclusion of every reasonable doubt. Does everyone agree with that legal concept? Shaking the heads, yes, thank you. It's the state's burden to prove that. So, a few moments ago I asked if anyone could define reasonable doubt. there's a definition. The judge is going to give it to you. We'll probably go over it throughout different points in the trial. But I find it easier to use some examples. Because presuming someone is innocent is not how our mind usually works. So, let's see. Number 5. Let's say this morning on your way in, you're pulling to the parking garage and you see a motorcycle cop pulling somebody over. What do you think? What do you think happened?
You presume they broke some type of traffic law or something.
You don't think to yourself, I wonder why that cop pulled that innocent person over, do you? Did anyone think that? Thank you. You probably thought, glad it wasn't me. That guy was speeding. That's the way our minds normally work. You see someone get pulled over, you're like, oh, they ran a red light, they were speeding. And as I said earlier, you may have done that when you walked into the courtroom this morning. Now, just because you think that way doesn't mean you're not qualified to serve on the jury. But it does mean that we can't have that kind of thinking interfere with part of your deliberative process. Does anyone here think that because law enforcement arrested Mrs. Adelson and the state has decided to charge her, and that we've got all the way here to trial, does that make you think that she is guilty in any way? And I'm going to start with number 22. Does that make you think that she's guilty in any way?
In a way.
In a way?
In a way. Because why the state wastes a lot of resources, time, and money to convict someone that might not be guilty.
Does anyone agree with number 22? Anyone else?
To an extent.
I'm sorry?
To an extent.
To an extent? What do you mean?
It wouldn't, in my mind, make sense for the state to spend, I'm assuming at this point, maybe 10, 11 years going after a person that they didn't believe was guilty, or that they had no reason to go after a person for that long.
Thank you for your honesty. Does anyone else agree with that perspective?
I don't think that it necessarily makes her guilty verdict, but I do think that to make it to trial at this point, there has to, at some point in our legal system, been enough substantial evidence or witness testimony or things that they found for it to be got to this point and not run out along the way. It's like, hey, there's not enough here. So there's something, but the burden of that, again, is on the jury to figure that out.
So with that in mind, is that belief that you have, is that something that you're going to carry into the jury room?
I think it's a belief that I carry into the jury room that we have to listen to that evidence and decide if it's credible or not. That's why you have a jury.
But I guess it was a poorly worded question. The fact that you believe that it's gotten this far, does that gives you some idea that Mrs. Adelson is guilty?
Not that necessarily, like I said, not that she's guilty verdict, but that there's credibility to some evidence that potentially may point that way, which is why we're sitting here today.
Okay.
I wouldn't just assume that it's just all a farce.
Would you say that you're pro law enforcement?
Sure.
So law enforcement conducts an investigation. They believe that they have probable cause. They make an arrest. You give that some weight.
Yeah.
You also said earlier that they could be wrong. How do we determine if they're wrong?
By what we're doing right now.
And just to be clear, the defense doesn't have to prove anything to you.
Right.
Okay. Does anyone think that it's not fair that the state has the burden to prove beyond a reasonable doubt with evidence and testimony, that the defense doesn't have to do anything? So let's go continue with the discussion.
Hold on one moment. Juror 26 have their paddle up.
I was just gonna say that, you know, somebody accused me of something, I'd want to speak up and say whether I did it or not, because I want to defend myself. And I want that opportunity to say, yes, I did, or no, I didn't.
And that's fair. Now, concept in our legal system is the defendant has the absolute right to remain silent. The judge is going to instruct you that if my client chooses not to testify, you can't hold that against her. Can you follow that instruction?
No, it's, oh, yes, definitely, yeah, just personally, I think that, you know, there should be some kind of response, but you're obviously the response for this.
Certainly, and I think that's human nature, that if someone says, you know, well, you did this, we want to speak up and defend ourselves. But in a courtroom in this country, defendant doesn't have to do that.
I think there's a time and place to speak up about things.
I don't disagree. Are you going to hold it against Mrs. Adelson if she doesn't testify?
Absolutely not.
Would anyone here hold it against Mrs. Adelson if she chooses not to testify? So let's go back to what beyond a reasonable doubt means. I'm going to give you another example. We've been in here for a while. There are no windows to the outside. So we walk outside when we're done, and the sidewalk and the road is wet. Is it reasonable to think that a fire truck drove down the road and sprayed everything to get it wet? Anyone thinks that's reasonable? No. That's not reasonable. In that context, can somebody volunteer what would be reasonable?
It rained.
Wait, we're in Florida. Does that happen?
Every day.
So we're defining what is reasonable. Does reasonable mean likely to happen? Is that what the judge is going to instruct you? Number 2.
Yes, sir.
So would you disagree with the statement that proof beyond a reasonable doubt means most likely to happen?
No, yeah, it's not most likely to happen. There's rarely like a case where it has every single aspect of evidence to it to fully convict someone. So it always be able to do it.
You know, I've been using these examples for a long time, and I think this is the first time that I haven't had to come back and say no, because most people would agree with likely. Standard is not most likely. It's not probably. It's not most convincing. So there are different levels of proof. And I think that you heard either the judge or Ms. Kappelman at some point talk about this. So at the bottom of the scale is reasonable suspicion. That's what's typically enough for an arrest. Or, I'm sorry, enough for an officer to stop someone, pat them down. Probable cause is what's necessary to get a warrant. Okay, so now, where on that scale we are, who knows? But that's enough to get a warrant, enough to arrest somebody. You got preponderance of the evidence, which is a civil standard. It's more likely than not. And you have clear and convincing evidence. That is what's required for the state to take your children from you. And at the top of that scale, it's beyond and to the exclusion of every reasonable doubt. That's the standard. So when you think about the state's burden of proof, how do you think about that from an operational standpoint? What is the state required to do? So let's go back to the chart. Who have I not called on? Number 8. Is the standard that you're going to be carrying forward into that jury room the side which convinces me the most?
No, your side doesn't have to convince me of anything. It's only the state that needs to provide evidence.
Can both the state and the defense make arguments that you disagree with?
Oh, sure. Everyone makes arguments.
That you believe the evidence does not support?
They could, yeah.
What are you going to do at that point?
Reconsider the evidence, deliberate with my peers.
And if the state has only proved something probable or possible, what are you going to do?
Well, it really needs to, I gotta get the abiding conviction of guilt. So I really need to feel that conviction that your client would be guilty after seeing all the evidence and testimony.
But that's exactly my point. If the state doesn't do that, you stop. It's not guilty. You understand that?
Yeah, that's what it says. Yeah.
So, in the definition, one of the words that you're going to see in there is exclusion. The state has to exclude every reasonable doubt. They have to eliminate it. Does anyone here at all, start on the first row, believe that they're going to have a hard time holding the state to their burden? They have to exclude every reasonable doubt. Anyone in the first row? Second row.
So when you say that, you mean that the state has to discount every other possible, like exclude to the exclusion of a reasonable doubt? Like prove to me that it's not possible?
No. Don't use the word possible.
Okay.
So, if in argument the defense were to say, give alternatives or a different explanation, and you believe that to be a reasonable doubt, if the state doesn't exclude that, then what is your response going to be?
Okay.
Does that make sense?
Gotcha. Thank you.
Does everyone understand that? I can make it real easy.
Before you go to the next one.
No, I can go past it. Yeah. The next slide yet. Okay, so one of the things that the court's going to instruct you is that a reasonable doubt arises from the evidence, a conflict in the evidence, or a lack of evidence. So this is another place where I like to use a hypothetical. And for this one, we're going to adopt the bank robbery hypothetical that Ms. Kappelman was talking about earlier. So the hypothetical is someone goes in and robs a bank. Witnesses identify the defendant. There's obviously surveillance video showing somebody that is consistent with the defendant's features. So
Please approach. Prospective jurors, we're just going to take a brief break for the moment, give you an opportunity to stand up and stretch your legs if you need to. I recognize that we are going through this process and it has been lengthy. If you need to stretch or take a moment to do so, you have the opportunity right now.
Okay, so I'm going to start that hypo over. So reasonable doubt can arise from the evidence, a conflict in the evidence, or a lack of evidence. And so the hypothetical, the bank robbery, someone goes in, witnesses identify the defendant from the stand, video evidence shows the defendant on the surveillance. Closing argument, the defense attorney gets up and argues that the state didn't put on any evidence to show that it wasn't the defendant's twin brother. How do you know it wasn't his twin? What kind of doubt would that be? Let's go to number 20. What kind of doubt would that be? Does anyone agree with her? Number 23, you grimaced. Oh, I'm sorry. I keep confusing these two. The chart's different. Number 11.
Yeah, that's a tough one. I don't know.
That's speculative. There's been no evidence the defendant has a twin. Now, the defendant took the stand in that case, testified that he has an identical twin brother who is a bank robber, and oh, by the way, I have an alibi. Now it's evidence. You understand the difference? Yes? Okay. That is a doubt which attaches to the evidence from the witness stand that was admitted during the trial. Reasonable doubt. Now, what would the state have to do about that reasonable doubt in order to convict that defendant? They'd have to exclude that doubt which attaches to the evidence.
His fingerprints versus his brother's?
We're going to get there. Thank you. So let's go back to that hypothetical. In the surveillance video, and the witnesses testify that the robber is wearing a mask, so no one can identify him. Whose fault is that? Is that the state's fault? Number 8, is that the state's fault?
He's wearing a mask.
Yeah. They can't prove who it is. Whose fault is it?
The burden would be on the state.
Right. So there's no identification. So the lack of identification is what? Reasonable doubt.
Yeah.
Let's go back to that same hypothetical. You got a mask. Robber's not wearing gloves, and he touches the table, he touches the glass door. You can see all that in the surveillance video. It goes to your fingerprint question. But reasonable doubt can arise from the lack of evidence. In this hypothetical, the detectives never bothered to dust for prints. Would everyone agree that that would be a lack of evidence which bears on a material element of the offense, identity? Would everyone agree to that?
Yes.
And that the state has failed to exclude that by not gathering the evidence. Does anyone disagree with that? Now, go back to the same hypothetical. Surveillance video shows that the robber's on his phone. The witnesses tell law enforcement that the robber was talking to somebody. Law enforcement later seizes that robber's phone, but they never search it to determine if there was a text or call made. Would everyone agree that there's a lack of evidence there?
Yes.
Another way the reasonable doubt can arise is based on a conflict in the evidence. In the hypothetical that I just gave you, can someone identify any potential conflicts? Can you?
Not off the top of my head.
What if they were to dust the table or glass for fingerprints, but it's not conclusive?
What if the guy was somebody who visited the place earlier and could be seen doing the exact same thing?
Now the state, before we move on, does everyone agree that witnesses that are going to come and take the stand are not perfect. They're not actors. They don't expect to see what you would see if you watch a TV program or a movie. Number 13, you were smiling.
I am. 'Cause I think before stepping into this whole process, there's an idea in your head that's put in there by culture on what it all looks like. But when you step in, it kind of is shattered when you go into the jury selection process right away. So, yeah, it's the difference between make-believe and reality.
And this is what?
This is reality, not entertainment.
Judge is going to instruct you on how to weigh the credibility of witnesses. Now, the state brought up a point, this is something that happened 11 years ago. Does anyone think that if someone doesn't have an accurate memory, that that's something that's going to matter here? Number 22. That's going to matter?
If the person doesn't have accurate memory, yeah, it will be matter because you will distort the whole information of the evidence you're going to provide to the juror.
Sorry, say the last part again.
Say that the information that you're going to provide to the juror will not be accurate.
How do you determine if someone is giving you an accurate answer? Would you compare it to the other evidence?
You cannot really tell.
I'm sorry.
So you cannot really tell unless you have the videotape or something that you can go back and review.
One of the instructions the judge is going to give you is you can believe or disbelieve any testimony from any witness. Okay? Ms. Kappelman talked a little bit about co-defendants. I'm going to talk about something else. Informants. I call them jailhouse snitches. Why would a jailhouse snitch cooperate with the state? I'm going to call on somebody I haven't called on yet. I think I've called on everybody. Number one, what would motivate a jailhouse snitch?
Special treatment?
Okay. Like what?
I don't know. What kind of amenities can they give? Maybe less time or comfort?
In evaluating the testimony of an informant or a snitch, should you consider what benefit they got in determining whether or not they're being truthful? Number 8, I saw you shaking your head or nodding.
Well, I mean, somebody can be getting a kickback and be telling the truth at the same time.
What do you mean?
I mean, they could have seen something bad happen and get a reduction in the sentence for telling on them. It doesn't mean that the person did something bad or did not do something bad.
So they could get the benefit, but it doesn't mean that what they're saying isn't truthful?
Yeah, I mean, they could be lying or telling the truth. Just because they got, a benefit or anything doesn't weigh on that other side of the equation in my mind.
Going back on the topic of informants or snitches, we had one opinion that just because they testify doesn't necessarily mean that they're being dishonest. Or honest. Okay, so we don't know. How do you determine whether they're being honest or dishonest?
The other evidence is presented, as well as their body language.
You got to weigh what they're saying against the other evidence, right?
Yeah.
Okay. Now, if you were to learn that the state can offer a benefit to an informant or a snitch, and it could be financial, could be favorable treatment, or anticipation of favorable treatment. On a scale of 1 to 10, with 1 being unfair and 10 being completely fair, where do you find yourself? And I'm going to go number 7. Is that fair or unfair?
6.5, 7.
Number 6. Number 5.
Probably 5. Find it either fair or unfair, depends on the situation.
Okay. Number 22. It'd be balanced.
Yeah.
Okay. Number 4. Yes. Number 24.
5.
5. Number 2.
Like you repeat that question?
On a scale of 1 to 10, with 1 being unfair and 10 being completely fair, where do you find yourself? If you were to learn that the state compensated or gave a benefit to an informant.
That would be unfair. For sure.
Okay. Number 1.
Scale of 1 to 10?
Yes.
6.
Number 8.
Initially, I feel like it's unfair, but when you think about it, no one does anything for free, and there's going to be a lot of risk to, coming out against a lot of folks that also could be in jail.
So it's a balance?
Yeah, it's a risk versus reward, and I think the higher the reward, the more of a risk someone is willing to take for that reward.
Does everyone agree with that?
Oh, yeah.
Getting a lot of head nods, okay. Number 9.
I'd say it's about equal. 5.
23.
I agree with mostly what he said. If it's...
Are you referring to number 8, sir?
Yes, yes.
Go ahead.
Number 11.
I'm a 5.
Number 12.
I'm gonna have to say 4.
Number 13.
I think I'm in the 4 or 5 range.
Number 14.
I think I'm at like a 7. I think it's fair.
I'm sorry?
I'm at like a 7. I think it's fair.
Okay. Number 25.
I'd say it's a 4 because the state then has more influence to pressure, whereas the other side would not have that same advantage.
Number 20. Can't read my own handwriting. Ma'am?
I'm 25. I think you said she was 25.
Yeah.
Just so you know.
Yes. Thank you.
About a 5.
About a 5?
Yeah.
20?
5.
19?
5.
18?
Is it legal?
It's legal.
Then it's fair.
Okay. Number 17?
I'm good with the 7 as well.
16?
It'd be hard for me to say, just that general circumstance would really depend case by case.
Okay. Just a moment. Does anyone think that the defense should have the same benefit there? The defense can do that as well? No? I'm sorry?
Could you explain what you mean?
Could the defense offer a benefit to a witness? If I were to tell you that we can't. Number 24. Is that fair that we can't do that?
I know that cannot, yeah.
Right. Is that fair?
I don't know, I just know as the law, you cannot.
Right. Number 14.
I think it's fair because the burden's on them to prove their case.
Fair. Now, has anyone here heard that a description of the role of a juror as having a duty to deliberate about the facts? Anyone? Getting some slight head nods? And once you decide the facts, you apply the law to those facts. What does deliberate mean? Let's see. Number 19, what does deliberate mean?
Discuss the facts of the case with your fellow jurors?
You trailed off at the end, I'm sorry.
To discuss the case with the fellow jurors in the jury room?
Does everyone agree with that?
Yes.
What does it take to deliberate? Do you think carefully? Consult with each other? Getting some head nods? Does anyone here, bless you, anyone ever engage in a family discussion around the dinner table? Show of hands. Are there informal rules for that? Number 7. What are the rules at your house?
Well, my dinner table has a 8-year-old, 6-year-old, and 2-year-old. So right now the big rule is don't talk over your siblings, and everybody gets to tell their part. Everybody gets a voice that needs to be heard.
And I've had children that age before. It can be somewhat difficult to wrangle them. How do you encourage them to follow those rules?
Sometimes with stern authority, but most of the time with the illustration of, hey, you want everyone to listen to you when you're talking, so you need to be quiet while your sister talks. I try to model that for them myself too.
Okay. So you redirect them. Sometimes you got to be stern, but you try to redirect them, and you try to use your own methods of showing them an example. Okay. Now, for those of us who have older children, let's see. Number 11. I know what it's like to have 4 children. How did you determine whether the family discussion was successful?
Well, I guess if we were all still speaking to each other and after the discussion took place was a success in my house.
I can relate. Now, would it be accurate to say that the end result, the conclusion that is reached, coincided with your initial conclusion?
Not necessarily.
Now, if you felt strongly that your way was the right way, would you be capable of standing up to them and saying, I believe this, I hear you, I respect you, but I disagree?
Absolutely. And that's exactly how it was in my household. You have the right to your opinion as well, and let's all try to understand each other and respect each other in that regard.
So in other words, can you accept that sometimes we just don't reach an agreement?
Absolutely.
Now, number 6. I think you touched on this a little bit earlier, but if you are engaged in that conversation and you disagree with everybody else's conclusion, but it's 6 o'clock on a Friday and you're hungry, are you going to change your opinion so you could go get something to eat? I don't think so. Does everyone remember why that statement causes me concern? Are you going to change your opinion? Anyone here willing to change their opinion if they believe that their interpretation is correct? Anyone? Getting crickets.
I'll change my opinion if the evidence suits it. My opinion's not set in stone or anything.
Well, let's back up a little bit. If you believe strongly, after having this discussion, that you're right, are you going to change your opinion so that everybody can go home?
I mean, there'd be a lot of peer pressure, I could see that, but, I mean, me personally, my opinion goes out into publication and all kinds of stuff, and we stake our reputation on that as PhDs. So only good concrete facts really change my opinion.
So, short answer would be no, you wouldn't change your opinion.
No.
Would anyone change their opinion so that they could go home? I'm getting shake. Okay, great. Are there topics that you should not discuss when you're back in the jury room? Anyone want to volunteer an example?
Anything you may have heard secondhand inadvertently through somebody, work, home.
What about whether the defendant should testify? Is that something that you should discuss back there? What does it mean if the defendant doesn't testify?
Nothing.
You discuss that. Number 7, should you discuss that the prosecutor decided to charge Mrs. Adelson? Well, you said earlier that if we've gotten this far, that it means something, right? Should that be something that you discuss?
No, I just think that's something that gets us to the trial. And the only thing we're discussing is what happens in the trial.
Does it matter what clothing I wear or my client wears? Is that something that you should discuss back there? Okay. Trying to find somebody to pick on for this. Number 13. Can you give me a definition of something that's, an example of circular reasoning?
It's an argument that plays back upon itself. So the argument is used as the evidence or proof that the argument is true.
I'm going to give you an example too. I like that one. I don't think everyone's going to agree with me on this, but good guys don't make mistakes. Law enforcement officers are good guys or gals. Therefore, law enforcement officers are good, I'm sorry, let me back up. Good guys don't make mistakes. Law enforcement officers are good guys. I'm a law enforcement officer. Therefore, I don't make mistakes. Circular?
I agree with that.
It's not accurate, is it? Do we want to avoid that type of reasoning when you're deliberating? Anyone disagree with that? Okay. Does anyone think that law enforcement officer who testifies should be believed over somebody who's not a law enforcement officer?
No.
Anyone? Number 17?
No.
No?
No.
When you're back there, would you be deliberating if you automatically accepted as truthful, without the exercise of any skepticism, the testimony of a law enforcement officer? Number 17.
Ask me again, please.
Would you automatically believe testimony of a law enforcement officer without exercising any skepticism?
No.
You wouldn't be deliberating, would you? You're just accepting what they tell you. You got to question what is said to you, what is presented. Do you agree with that?
I do.
Does anyone disagree with that? Just going to accept what is presented by the witnesses. Anybody? Good. Now, I'm going to go back to you, number 8. When you're deliberating, you have concluded your conversations. You believe that you're right. You said that you're capable of standing your ground, right?
Yes, sir.
Okay. Now, what about the reverse? You go back there, you believe steadfast in your position, but then somebody else adds something that you hadn't considered. Are you going to then consider that as part of your deliberative process?
Yeah, that's the whole goal. Sir.
One of the instructions that you'll get from the court says that you should use your common sense. Is common sense a process or is it a result? Let's see, who do I want to use for this one? Number 2.
Well, I say it's a process.
And so if common sense is a process, should you automatically accept the state's conclusions without discussing it? What should you do?
I mean, common sense might be common, but it's not always the answer, so you could have something different. So you need to be skeptical of everything. Even common sense can be wrong sometimes. So.
Are you capable of saying, if someone's common sense result, their process, leads them to one conclusion, but your common sense process leads you to another, how do you resolve that? Or can it be?
Go back to what you assume is common, the common sense, and kind of discuss those. What's so common about it? What are you hinging the common part of it on? Like, what do you actually think is so reasonable about it?
Thank you. Ma'am?
Number 26. Go ahead.
I don't think we can, in all fairness, always trust our common sense, because I think we all have to say we have common sense, but circumstances change, and when circumstances change, we need to rethink whatever our common sense is telling us.
Does anyone agree with that? Getting some nods. Anyone disagree with it? Now, you've heard the court read the charges against my client. One of the things I want you to understand is what's going to be necessary as you are evaluating the evidence. Ms. Kappelman asked, how do you determine someone's intent? Does everyone remember that? It's not just, does somebody always say what they intend to happen? Shaking your head? How do you determine it though? With their words?
Yeah, that's part of it they take into account, but how they would benefit from a different outcome, body language, what they're telling you, and compare that, weigh that against other evidence and what other witnesses said.
Now what's clear is throughout the case, everyone understand that you don't reach a conclusion until you don't start deliberating until after all the evidence. Okay, so when you get to that point, all the evidence has been presented. At that point in time, you guys then have the opportunity to go back and discuss what the evidence means. Does everyone understand that? Shaking the heads, yes. Now, if the state establishes that there's a premeditated killing of Daniel Markel, and that Daniel Markel is dead, does that mean that it was done by the criminal act of my client? You need to be able to separate my client from the other individuals. Does everyone understand that?
Yes.
principle. Ms. Kappelman discussed it earlier. The important thing to take from this is the state's going to have to establish Mrs. Adelson had the conscious intent for Daniel Markel to be killed. How do you determine if someone has that? Number 5, how do you determine if that happens? How do you determine if the state can prove that?
There'd have to be some sort of evidence, like witness testimony, writing, something along those lines, that there was premeditation, some sort of plan.
Now, in the principal instructions, the state's not going to have to prove that Mrs. Adelson was present. Have you heard the term guilt by association? Anybody? Oh, yeah. Shaking the head, yes. Now, there's going to be testimony that my client's son, Charlie Adelson, was convicted. Does that mean, and I want to, anyone, does that mean that my client has any involvement, that she is guilty? Shaking your head, no. Anybody saying yes? Is that conclusive in any way concerning Mrs. Adelson? Shaking of the heads. Let's see. Number 7. Is that a factor that you're going to consider when you're evaluating the evidence?
Can you ask it again?
Sure. The fact that my client's son, Charlie Adelson, has been convicted of these charges, is that something that you're going to consider when determining whether or not my client is guilty?
Sitting here right now, no, but if the state uses some sort of, I mean, it would just be determined on if the state has a connection or if they present some evidence, that would have to be considered.
Okay. Is it conclusive?
No.
So what you're saying is the state would have to have evidence connecting Mrs. Adelson to her son's actions.
Sure, yeah. Just can't do
They
it
would
wrong, isn't it?
have to have evidence beyond a reasonable doubt.
Yeah.
Does everyone agree with that?
Yes.
Anyone disagree? Just because he's been convicted doesn't mean that my client is guilty.
Correct.
Before we approached, we were discussing other people's responsibility. There's only one person that's going to be on trial here. Does everyone understand and agree that your feelings about anybody else and whether or not they have any responsibility have nothing to do with Mrs. Adelson's responsibility? Everyone can separate that. Focus your conversations only on Mrs. Adelson. Does everyone agree? Okay. Let's see. Looking for somebody with older children. Number 11, I'm going to pick on you again. Kids ever lie to you when they were growing up? Say it again.
Absolutely.
How did you determine if they were lying?
I had pretty good kids, so normally they felt guilty enough to come tell me to me. But typically, as a parent, it's fairly easy to pick up on when your kid lies to you for the most part. The older they got, the more difficult that was. But
So your children are adults now.
correct.
They ever lie to you as adults?
Oh, I'm sure they do.
Have you caught them yet?
A few times.
Number 16, how do people react when they're scared?
Very much depends on the person. Someone's going to have a lot of big emotions. Someone else might kind of go into a fawn response.
People don't react the same.
Sorry?
People don't react the same when they're scared.
Correct.
Everyone agree with that?
Yes.
You know, I grew up in Miami, and I had a friend whose family was featured on a reality TV show after Hurricane Andrew. He quickly discovered he didn't like that type of attention. Anyone experienced something similar where they've been in the spotlight and they didn't want to be there? Number 16, you're shaking your head yes. You've been in the spotlight before, you didn't want to be there?
Something like was on local news as a kid, didn't like that.
I'm sorry, I couldn't.
Yes, a little bit. Like when I was a child, I was on local news and got very shy during that.
Okay. You wanted to get away, right? Does everyone understand that that feeling you want to get away from unwanted attention? Yes? Now I'm going to ask you something I don't normally ask in jury selection, and I apologize if I offend anybody. By a show of hands, anyone familiar with Judaism? Thank you. Are there important life events that happen in the lives of Jewish children? Was your grandmother at yours?
I'm not.
Oh, okay. My grandmother was at mine. I'm going to bring up something else that's a little unique. And who was familiar with Judaism? Okay. Let's see. Number 12? That's you? Oh, 14. I don't know why I can't keep this straight. I'm sorry.
That's all right.
Actually, I'm going to skip that. Let's see. During the course of the trial, there are going to be some photographs shown of Mr. Markel. Is anyone particularly averse to gory scenes? Nobody? Number 9? Can you talk to us about that?
I get fairly squeamish about that kind of stuff. I'm not passing out the sight of blood, but other stuff that are more gruesome is just a bit unsettling.
Okay. Is that something that you wouldn't be able to review that evidence?
I should be able to review that evidence.
Should be?
Yes,
or
sir.
will be?
Will be able to.
Okay. Is that going to impact your ability to be fair in evaluating that evidence?
No, sir.
I want to ask a somewhat provocative question. At this point in time, does anyone here believe the state actually knows what happened? Anybody?
Say that again?
Do you believe the state knows what happened?
Can you clarify that like a little bit more?
Sure. As we sit here today, now remember, prosecutors were not witnesses to this case, correct? They are going to present arguments to you, correct? So as we sit here, do you believe that they know what happened? Or do they believe what happened? You understand the distinction? Does everyone understand that?
Yes.
Okay. Just a moment, Your Honor. Two heads are better than one becomes three heads are better than one, Your Honor. And nothing further.
Kappelman, do you need to make any inquiry of juror 26?
Ma'am, were you able to follow the discussion when I was doing my presentation? As far as we talked about principal theory, I gave my circumstantial evidence demonstration with the cheesy donut example. Anything that you felt like as you were sitting out there listening, oh, I would definitely interject at that point? Or has your mind been numbed so much at this point you can't harken back that far?
I was listening to everything you were saying. The only thing I would have interjected at the moment, I was thinking, I want to say this, but I don't want to say, I couldn't say it, but, you know, I would always consider a person's character when as to whether I believe them or not believe them.
So in the context of, oh, you're going to hear from some witnesses who've been convicted of felonies, who live a different lifestyle from you, that kind of thing, is that the discussion where you were having that thought?
I try to be open-minded, and I think there are all kinds of people, not everyone, so I don't want to prejudge a person because I don't know what the circumstances are. That's why I go to ponder the evidence and decide from that point.
Okay, so can we agree then that although that's those types of characteristics or character, as you said, are something to consider, they're not the end-all be-all, and you can keep an open mind to the testimony, does it fit with the other evidence in the case, that sort of inquiry?
Definitely, I think considering everything is extremely
Okay, as opposed to being the type of person that, oh, I hear they're a felon, I'm done, I can't hear anything they have to say.
I think that's very negative thinking to think that way.
Anything else during my time up here where you were bursting at the seams to share something with me? Okay, thank you, nothing further.
If the parties at this point can join me in the jury room along with the court reporter. For everyone else that is going to remain in the courtroom at this time, I'm going to instruct you once again, do not discuss the case with each other or anyone else. If you do need to stretch your legs or use the restroom, you may do so, but you do need to return to this courtroom. We're in courtroom 3G. No one is to take a tour of the courthouse by themselves. Please come back to courtroom 3G as soon as you finish with the bathroom, using your phone or stretching your legs if you need to. If the parties can please join me in the jury room.